Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode, episode 98, we're going to look at a recent Colorado Supreme Court case, and we're going to dive into the question of whether a deceased client's files held by an attorney are property of the estate that can be accessed by the personal representative or other legal representatives that have authority after the decedent's death. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So, as a starting point, our big proposition here is what can your personal representative see? So, the thing that few clients consider is that once a personal representative is appointed, or an executor, depending on which state you're in, that lays bare all of your affairs that might be recorded in any sort of physical medium. So papers, files, even electronic copies of those on your computer might be able to be accessed by a personal representative. Now, with digital assets, there's a whole other issue that we don't need to really deal with in the context of today's discussion, but for the time being, what we're focusing on here is legal files. In other words, can your discussions with your attorney be exposed following your death? And that was really the issue in the Colorado Supreme Court case I alluded to. And in that case, the decedent died and left everything under his will to his widow, and the widow was also named as the personal representative. But, as often happens, creditors come out of the woodwork, and in this case, the creditor was the decedent's ex-wife, who made a claim against the estate based on a promissory note that was signed by the decedent during his life. So the widow found this out and went digging. She wanted to know more about the validity of this claim, as was her duty. So the widow, as the personal representative, went to the decedent's attorney, who had handled all his affairs for most of his life, and asked for all legal files, which the attorney refused based on the fact that that's privileged and confidential information. But the attorney did offer, after some further discussion, to disclose the documents relating to the promissory note. And one little tidbit in the case was that the attorney concluded that the written notes relating to the promissory note, along with the note itself, those were not privileged because the ex-wife had been present when the note had been negotiated and signed. So that privilege had been waived, at least with respect to the note, which became of no consequence anyway, as we're going to see later on. But in the meantime, the widow took that, settled the claim, but still subpoenaed the attorney for all files, maybe because, she thought there was something in there that, could be relevant, and the attorney sought to quash this subpoena based on the fact that the files were privileged and confidential. So this case went up on appeal after a lot of procedural history, and what happened is that the widow argued that as the personal representative, she was entitled to all of the decedent's property, which is true under Colorado law, but she tried to argue that property included the decedent's legal files. And the widow further argued that the decedent's death terminated the representation, so that the attorney had an ethical duty to return the decedent's files at the termination of that representation. But the Supreme Court here disagreed and stated that the attorney-client privilege survives the decedent's death, but it is personal to the decedent. It's not a property right that passes on to the estate or that is within the authority of the personal representative. The court also concluded that the attorney rules of professional conduct are what drives this obligation to return files, and those aren't necessarily a state law property right. It's simply an ethical duty of an attorney. So there's no enforceable right of the personal representative to get the decedent's legal files just because the decedent has died. And then further, the court elaborated that this isn't a hard and fast rule. It wasn't black and white. There could be part of the legal file that is property, but it would really just be those parts that have items and choses which are evidence of value or property, or which determine the value of property. Things like promissory notes, as was the case here, certificates, titles, wills, and trusts, things of that nature. Finally, on the privilege and confidentiality issues, the widow tried to argue that the personal representative of the estate personally basically acceded to the decedent and stepped into the decedent's shoes, and that in that capacity, the personal representative could waive the attorney-client privilege and the duty of confidentiality. But the court here also disagreed and really held that the privilege and confidentiality were personal to the decedent and only could be waived personally by the decedent. So the personal representative had no authority to waive privilege or confidentiality on the decedent's behalf unless the decedent himself had waived that privilege and confidentiality through an instrument such as a will. And, moving on from that, the court elaborated that the attorney's only ethical duty or authority in this case to disclose privileged and confidential information really only extended to the fullest extent necessary to administer the estate. So anything in the files that related to affairs of the estate, settlement of claims, as was the case here, or determination of assets and property rights, that could be disclosed, but everything else would remain privileged and confidential. So, given these issues, it seems like this was a very client-friendly ruling, but there are several issues that can come out of this. I want to kind of hop around on this slide and remind you that the only real failing here is that the personal representative made no attempt whatsoever to limit the scope of the records that she was seeking, and she unsuccessfully fought to claim that no such limitation of scope was required. If that limitation had been requested, then this probably wouldn't have gone up and become a Supreme Court opinion. So, with all that being said, for one, if you're engaging in estate planning or implementing an estate planning document, it's important to make sure that the will or revocable trust can't be interpreted in a way that might imply a waiver of attorney-client privilege or confidentiality as to all of the decedent's affairs. And two, it's important to remember, again, that this ruling only goes so far as to protect information not relating to the settlement of the estate. So even though the personal representative here went for the whole enchilada, this issue could come up again, and it could be posed in the future in a way that says that the subpoena is going to try to claim as much of the files as possible under the justification that they relate to the administration of the estate. So if the personal representative had tried to say, hey, all files might pertain to the administration of the estate, instead of just simply saying, hey, this is property I'm entitled to, then the subpoena might not have been quashed and she might have been successful. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.